Could I welcome our new witnesses before us, and in a moment I'll ask you to introduce yourselves. Unless any members can tell me differently, I'm sitting here on amber alert for a division in the House. If a division does occur, the knives in terms of timing still apply. So we lose that time from this session. So what I propose to do, unless anybody can tell me differently, is to obviously to invite members to to ask questions, one question at a time, so as many members can ask a question, and if the worst comes to the worst, we'll then have to suspend for the division. If I could ask our witnesses from left to right, starting with Mr. Solomon, just to say who they are and who they represent.
Yeah, my name's Enver Solomon. I'm Director of Policy at the Children's Society, and I'm here in my capacity as Vice Chair of the Standing Committee for Youth Justice, which is a membership body which provides a forum for nearly 30 organisations, primarily non-statutory sector organisations, who are working to promote the welfare of children who become engaged in the youth justice system, and we advocate for a child-focused youth justice system that promotes the integration of children into society and which is premised on recognising the rights of children and their voices to be heard.
Dr. Atkinson.
I'm Maggie Atkinson. I'm Children's Commissioner for England, charged to promote and protect and ensure the delivery of children's rights under the United Nations Convention on the Rights of the Child in all aspects of policy that affect their lives.
I'm Barbara Eastham. I'm a solicitor with the NSPCC in the Policy Department.
David Simmons. I speak for the local government group. I'm also Deputy Leader of London Borough of Hillingdon and serve as a magistrate in the London Borough of Brent.
Thank you very much indeed. So one question at a time. We'll see how we get on, starting with Alex Cunningham, Elfyn Llwyd and Andy Slaughter.
Thanks, Mr. Holborn. This question really is for Mr. Solomon and Dr. Atkinson. Are children properly protected in the justice system in the light of the legal aid cuts?
Enver Solomon.
Yeah, I mean, from our perspective, from the Standing Committee, we focus primarily on youth justice. The legal aid reforms are particularly of concern in relation to the children's rights perspective. I think we're particularly concerned around decisions that have been taken about what remains out of scope. We asked for data, the Children's Society, from the MOJ in relation to legal aid representation for under 18s, and the data that was given to us shows that nearly 990 cases will remain out of scope. That's 5% out of scope for legal aid representation. That's 5% of cases for the most recent data for 2010-11. That is £8 million. So we're talking about saving a fraction of the total spend here. The majority of that is in relation to clinical negligence, which is accounting for about £6 million. I think the point being here that we believe the fundamental right to representation for all children under 18, a recognition has been given that children in family law are not able to represent themselves, but there seems to have been arbitrary decision-making about whether or not children can represent themselves in other elements of law. And there's a principle here, particularly that we feel strongly about, that there needs to be a differentiation between children and adults. I think the impact assessment doesn't make that differentiation. I think the government has approached this reform and this desire and speed for legislation which is premised on an economic imperative, not a principled imperative that recognises that children are fundamentally different developmentally, and are unable to represent themselves in the same way as children and as adults, and access to justice and issues of equal justice need to be seen differently when it comes to children than it does for adults.
I'd add to that, Chair, that we are bound not only by the international and national articles that are quoted on the face of the bill, but also by the European Union's last autumn's child-friendly justice guidance, which makes it very clear that children are in and of themselves as a population already vulnerable. And as your former evidence givers in the last session indicated, legal aid is almost always concentrated on those who are least able to fund their own access to legal redress. And we are very concerned that young people who are leaving care and who don't necessarily have access to the resources that they might need to set themselves up independently are out of scope. Young people who've experienced criminal injuries, including abuse, and very particularly young people left severely disabled in cases where there are contested issues of clinical negligence. They may live a very long life, and they have a right under the United Nations Convention to the best possible quality of life and to a system that does everything it does in their best interests, irrespective. Therefore, as Children's Commissioner, I am concerned. I must point out that I'm speaking only about England here. There is a Commissioner in Wales who will no doubt be talking to you, if he wishes to, about the Welsh situation. It's very important to us that we understand that litigation in person by a child is completely inappropriate in a court system which, even in family law, remains adversarial rather than inquisitorial. They are already vulnerable, many of them are already very damaged, and lack of access to legal aid seems to us to be another insult.
Thank you. Elfyn Squid.
This bill introduces a new offence of threatening an individual with a knife or bladed instrument in public or on school premises. Will carry a mandatory 6-month sentence, but this will not apply to under 18s. Do you think it should apply, and if so, why? Can I just say, obviously there's a prevalence of this kind of offence amongst young people, unfortunately. It even mentions school premises. So what's your view on whether that 6-month sentence should apply to under 18s?
David Simmons.
Yeah, I mean,
sorry,
I don't
Solomon,
think
David Simmons.
Sorry.
This is, I suppose, a personal view expressed from experience as a magistrate. My view would be no. I think in the courts we do go to great lengths to try and make sure that young people are not sent to prison unless that is the only available alternative. And I think the figures on sentences of prison for breach do demonstrate that in many cases where an offence of that nature has been committed, the courts do try and give another chance to that young person. If they make the best of that chance and reform themselves, then they won't find themselves back in front of the court again. But if they do breach that order, then a prison sentence will be activated. And I think that discretion should remain in place.
Inver Solomon.
Yeah, I would back that up. I think that the purpose here needs to be about proportionality. And I think proportionality needs to be one of the key factors in determining the sentence. I don't see a need, the Standing Committee would not support the approach of a mandatory sentence in this case. I think that, as a colleague said from his experience as a magistrate, I think that view would be supported by other magistrates. I think the options that are available to the court to deal with children that get involved in various serious knife offences are sufficiently robust and could result in sufficient custodial sentences if the cases merited it.
Are you saying, therefore, that there was no need for the provision?
There's no need for a mandatory requirement of a custodial sentence.
But the offence itself, I mean?
Sorry?
Are you saying in any way that the offence itself is unnecessary?
No, I'm not.
But you said the law was sufficient earlier on.
Well, I'm saying that there's other categories in relation to possession and in relation to acts of violence that could be applied if, you know, that might currently apply in current cases that would come under this offence category.
Robert Buckland and Andy Slaughter.
Thank you, Mr. Baldwin. I just want to explore with you alternatives to conviction, or indeed alternatives to the usual range of sentences for young offenders. The bill contains reference to conditional cautions and other alternatives, but in that context, the restorative justice and its value, I think, has been demonstrated by a number of young offenders teams across the country. And I would like to know the views of the panel as to the future role of restorative justice with regard to young offenders and how they see that particular aspect of sentencing or alternatives to conviction as rolling out in the years ahead.
Can I take this first on a general basis and entirely based on the sorts of evidence that we collect as the Office of the Children's Commissioner whenever we speak with young offenders and those who work with them? There is a great deal of very solid evidence, as you've just said, that restorative justice approaches not only work for victims and the offender themselves, but can be a really solid mechanism for turning around the lives of young offenders. our very recent report, launched in this building, I Think I Must Have Been Born Bad, points out very strongly that there are always at least two victims when a young offender offends. The first is the victim of the crime that young offender commits, but the second is almost always the young offender. Huge percentages with very special needs, with real family issues and background difficulties, with all sorts of mental health problems. A restorative justice approach seems to me to be one of those things that you can and should use with young people, because it's multi-agency, because almost always it involves mental health and physical health professionals as well as those in the justice system itself. I was in an about to be reopened, brand newly refurbished local authority service secure children's home only last week, where restorative justice programmes are at the heart of what they'll do when they move those young people into a fantastic new setting that will help them turn their lives around. And when they leave, more importantly, should leave them able to call on what they've learned from restorative justice the next time they're faced with the temptation to commit an offence. That's the real fruit of restorative justice when it works well, for the offender as well as for the victim.
I would endorse that point, and many of the members of the Standing Committee believe there is robust evidence to support the use of restorative justice. You only have to look at Northern Ireland. I know the Minister has been to Northern Ireland to see the conferencing model in operation. The Prison Reform Trust, which is a member of the Standing Committee, has produced a very robust report outlining the beneficial outcomes indeed in relation to reduction in reoffending, where restorative justice is used in an effective way, and the conferencing model. In relation to the specific bill, we welcome the loosening of the restrictions upon the use of the referral order for children, which of course, as I'm sure you are aware, includes a restorative element, and we hope that guidance can ensure that they become a more restorative process with higher levels of victim involvement than at present. We believe that they should also be extended to cases where a child is convicted after trial, providing that following the conviction they admit their involvement in the offence and agree to abide by the referral order. So we're supportive of what the legislation is doing with that element of restorative justice, and would argue it could be taken further. In terms of out-of-court disposals, it being used as a first-tier option, a restorative element which is very much focused around the police and the delivery of a restorative intervention or part of a conditional caution. Again, we're supportive of that, but the critical element will be in the delivery, the implementation and the resourcing, and also who implements it.
Andy Slaughter, Liz Truss, Helen Goodman.
The government continues to set out its proposals for reform of probation services, and this week it announced the outline, not the detail, of the competition strategy for non-custodial services, and there are significant cuts already to probation and particularly to youth offending teams, and yet there's a lot in this bill in relation to young offenders and additional requirements put onto those teams. Does that seem to you to be a problem? What are your observations, what are your concerns about the way the ops are working at the moment?
I was a director of children's services before I took this job, and youth offending team was part of my remit as director. They do fantastic work, particularly the preventative teams, but they don't do that work in isolation. What local authorities and their partners are becoming ever more creative at doing, as the savings and the cuts bite for them, is using people who are not in the youth offending teams but meet the same young people to do some of the diversionary, community-based, community payback, restorative community action work that youth offending teams might previously have carried entirely on their own. There are also a lot of preventative strategies at work in schools. So almost mediation and restorative approaches within the school setting that can stop a youngster beginning to offend in the first place. Any yacht manager you had in front of you would tell you that their mission in life was to put themselves out of a job because they want to reduce offending by young people. I do recognise that cuts are biting, and that there are something like 18% was the last figure I saw quoted, reductions in the funding for youth offending teams. This therefore becomes not something that you can simply pass to a well-meaning but ill-trained volunteer, lest anybody think it is. People who work in youth offending teams are very specialist indeed, and they're multi-agency. It's about how those localities therefore meet that challenge without letting young people fall into risky behaviours, of being offended against as well as offending. I would imagine the Standing Committee has other things to say, Chair, but and so would colleagues.
Inver Solomon.
Yeah, our committee includes the Association of Yacht Managers, and we know from them that the picture in relation to yachts is a changing picture, and actually we don't have clear information. In some local authorities, yachts are being merged with other reforms or structures. In some areas, a discrete head of the youth offending team or the youth offending service is being taken out, and they're being led by someone who has additional responsibilities. There is a changing picture. We do know that youth offending teams, as currently constructed under the Crime and Disorder Act, are going to change significantly, we would expect, in the course of the next few years. The notion of having a discrete multi-agency team whose primary purpose is to deal with crime prevention and reducing offending and reoffending will, I think, undoubtedly change. We will not, in every single local authority, have a discrete team with that focus and with that purpose. And as a result, the delivery of youth justice and the kind of resource and capacity and specialism associated with it will undoubtedly change.
David Simmons.
It's a very brief point, but I think restorative justice is generally a lot cheaper than custody. And when we see, certainly my experience, reducing the number of young people from a borough going into custody by roughly a third, the cost of that reduces dramatically as well. I think the provisions that are envisaged about transferring the full responsibility to local authorities, which would mean that the full financial picture was held in one place, would enable us to see the benefits of doing that more clearly.
Could I just a quick supplementary to that? Does that mean, Councillor, you would like to see, if there are savings generated, of course youth custody levels have been falling quite substantially, you would like to see those reinvested in schemes like whether community payback or restorative justice in that way?
Yes.
Liz Truss, Helen Goodman, Tom Brake, Dave Watts.
Thank you, Mr. Chairman. I want to return to the matter of legal aid and specifically the scope for children in the legal aid system. My understanding is 95% of what is currently covered by legal aid will be covered by legal aid for children under the proposals. And issues such as special educational needs have been brought within scope of the bill, which were previously out of scope. And that 5% of cases that are no longer specifically provided for under legal aid are mainly clinical negligence, which can be covered by CFAs. And in some of the most complicated cases, there's also an exceptional fund at the discretion, I believe, of the judge. So isn't it the case that all children in difficult circumstances are going to be able to find recourse to justice, either through the legal aid which has largely been preserved, or through CFAs, or through the exceptional fund?
No, I don't think that is the case. I think that we're very concerned about the number of cases where vulnerable children are involved in family proceedings that will not be cases that fall into the scope of legal aid any longer. And we're particularly concerned about the effect that will have on an increase in the number of litigants in person who are appearing in court, and the result that will inevitably bring, which is huge delays in an already overstretched court system. We have noticed the information that the Ministry of Justice have on their website in relation to a literature review of litigants in person, and I think it's almost the strongest argument against the proposals within the legislation for cuts to legal aid that affect family proceedings. It goes through the research that indicates that litigants in person experience a number of problems which impact on the court. And those include the fact that they're not able to understand evidential requirements, they have difficulty with the forms they have to deal with, they have difficulty with identifying relevant facts. And they're often, according to the MOJ's literature review, overwhelmed by the procedural and oral demands and have difficulty explaining their case. They also go through the impact that this has on the case outcomes. and it indicates in most of the evidence that the case outcomes are adversely affected by lack of representation. We're very worried at the NSPCC about the negative result that the lack of legal aid will have, therefore, in relation to these cases.
Chair, if I can add one further strand. You will know that both under my predecessor, Professor Sir Alan Ainsley Green, and myself, we've been concerned as the Office of the Children's Commissioner and indeed involved in changes to issues to do with children and young people involved in the asylum system. We were asked, under my powers, to intervene by a legal representative in the case of a child and a family. And I'll briefly tell you about it, if I may. A foreign national imprisoned on very serious charges, then further detained under the immigration rules, had 3 children, one a 16-year-old, almost at the end of her GCSEs, who'd made a life for herself. The children were living apart from her and each other in different sorts of local authority care. When the government decided to deport the mother, they included every child in the family within that deportation order. The 16-year-old expressed the view that having made a life for herself and being about to sit her exams, she should not be made to go, and she didn't want to go. We intervened. Had we intervened under the bill as it's currently formed, and should this bill become law, she would not have had recourse to legal aid of any sort, and nor would the family. And as asylum seekers, they had no other recourse to public funds. Unfortunately, the case went through and was lost, but that is not the point. The point is that she had recourse as a very vulnerable young person who'd already been through the trauma of her mother being both a criminal and a failed asylum seeker. She would not have had recourse to legal help, and she spoke English as a second language, and all of the things that have just been summed up. That's only one example, but there are many, many more. And I think Lord Hill's very encouraging, Lord McNally's very encouraging statement that wherever possible, when he spoke about this in the Lords, wherever possible, children and young people would be given legal aid. That's absolutely welcomed. I would welcome that very strongly indeed. But it's how you define wherever possible.
Helen Goodman, Tom Brake, Dave Watts.
One of the proposals in the bill is to increase the fine for breach of a YRO to £2,500. Do you think that the courts will have the common sense not to use that, or do you think there could be some adverse impacts? And if there are, what might they be? I don't know whether David wants to.
Well, I think my view
David Simmons.
The courts are unlikely to impose a fine where they believe it's inappropriate, and in my lengthy experience of such things on all different types of offences, it is very rare that a court seeks to impose the maximum fine unless there is clear evidence that it is both justifiable for the offence and affordable by the perpetrator.
So there's not really any point in having a law that can't be used, is there?
Chair, we're in the area, it seems to me, of one of those escalator things, technical term, where somebody is brought before the bench for a minor matter and a fine is imposed. The fine is not paid and it becomes a criminal matter. And they don't turn up and it becomes a further step up the ladder of the criminal matter. Before you know where you are, you've got somebody who is out of scope of the magistrate's court and is suddenly somewhere in a higher court in the land because they didn't pay a whatever it was fine. That includes for things like, school truancy and goodness only knows what else. And I think we need to be very, very careful, and that raising the fine to that level would be one of the things that would almost put the system at odds with itself. And I think David's just summed that up really well. I don't know whether the standing committee has things.
I mean, I think
Member Solomon.
From our perspective, the sum of £2,500 is just grossly unrealistic that a child would be able to pay that, or a young person. But I think there's a broader point here, and in our briefing on the bill we said that it could be capped at £250. But there's a broader point here, that there's an extension of adult provisions, and this is one of them, to apply to children, which are just wholly inappropriate. The other two, if I might draw your attention to them, Clause 67, the extension of curfew requirements to a maximum of 16 hours per day for up to 12 months, and also the extension in Clause 69 for the maximum period of the youth rehabilitation order to 3.5 years. These are essentially extensions of adult provisions, applying them to children, that won't in any way impact on reducing reoffending or promote youth rehabilitation.
I would support that, Chair.
Sorry, I'm coughing again. Oh dear.
Tom Brake.
Yeah, you had your chance.
There. So could I bring us back to restorative justice? And first of all, a general question about whose responsibility is it to ensure that there are actually restorative justice schemes up and running, because there's a very patchy provision of this, and yet the advantages seem to be enormous. And secondly, we had an interesting debate earlier this morning about what types of offences, mediation and restorative justice is clearly that, what type of offences might sensibly be dealt with in a restorative justice context. And I'd be interested to hear, in your experience, whether there are types of offences that young people have committed where victims will never agree to have restorative justice type arrangements in place.
David Simmons.
Well, I can make some observations about that, although I'm not a legal expert. I found generally what one might broadly term environmental crime, graffiti, vandalism, that sort of thing, generally a very positive response to restorative justice. And for a young person who has been graffitiing property, to spend time cleaning it up, talking to the property owner about the consequences, has been quite helpful. I would suggest that there are certain categories of crime, sexual crime, crimes of violence, where by and large victims are not keen to engage in restorative justice. Not always, but generally would not be keen.
And the general point about who should be pushing for restorative justice schemes?
Well, I think in response to the provisions in the bill about local government holding the ring on this, I think given that what we're seeking is a situation where the lower cost of restorative justice is a benefit in a broader sense, then provided those costs and those benefits sit with local government hold it, but you could equally transfer that provision to the probation service or any other part of the system. But I think it needs to be in one place.
Dave Watts, Robert Buckland, Kate Green.
Can I take it back to the scope? I think many of us are surprised that clinical negligence is not involved, it is not included in the scope. We've heard from previous witnesses that it's unlikely that many solicitors will want to take the cases on, bearing in mind the high upfront cost and incurred and the chance of not receiving any fees whatsoever. We've also heard in the bill that there's this discretion from the judges, from a judge, to break away and to grant bail. Do you understand that? And what do you clear about what the grounds would be that would make a judge be able to recommend that legal aid was provided in such a case?
I don't know enough of the detail, but we'll make one general comment, which is that everybody who's shared evidence with us and shared briefing notes with us finds it difficult, bureaucratic, cumbersome, slow, and likely to be at least as expensive to administrators to find the money.
Robert Buckland.
Can I just come back to an issue I think was raised by Mr Solomon about extension of YROs, youth rehabilitation orders. I don't think you made the point fairly, but I just wanted to press you somewhat on that, because we're dealing with potential extensions of term, aren't we? If, for example, there's been a failure to adhere to requirements within the 3-year period. So what is being proposed is really an extension of discretion by the court in order to impose an extra term if there had been a failure to comply with a condition within the 3-year period. So it's not a simple question of inflation in terms of allowing a court to impose a 3.5-year period at the beginning of the sentence. It's all about the potential of giving the court leeway to impose a further term if insufficient progress was being made by the young person or if there was a breach.
I think you're referring to Clause 66, which is in relation to allow the court to impose repeated further periods of supervision for breach of a child's detention and training.
69,
69.
I think is the one, yeah, that's YROs as opposed to DTOs. Yeah.
Okay, yeah.
Ember Solomon.
I think the point here is that what is going to facilitate a reduction in reoffending and promote rehabilitation and that the evidence is very clear from criminological research that for young people under the age of 18, sentence length does not act as a deterrence. The length of sentence does not make a difference. What makes a difference to a young person is what happens to them in the course of their experience within the youth justice system. If they are given opportunities to engage in education, training, skills training, if an approach is taken which addresses the factors behind their offending, and if critically there is resettlement support for that young person on leaving custody. There was a recent report by Her Majesty's Inspector of Custody, of prisons, which was quite frankly damning about the nature of resettlement support. And this is an issue which we have been trying to get to grips with for many, many years, and we are still failing to do it. Those are the elements which determine whether or not a young person will return to the community as a law-abiding individual or not, and those are the critical elements. I don't think an extension of sentence length is going to address that. I recognise, and I would never argue that one should make excuses for breach, but there needs to be discretion and there needs to be a proportionate response to breach, and we need to recognise that young people critically learn by making mistakes, and unless we recognise that, we will not facilitate their rehabilitation.
Maggie Atkinson.
Chair, I think that the point I'd like to make is that one has to realise that whilst 3 years or 3.5 years or any period of time in an adult life is a bit of a blink of an eye, in the mind and the life of a child it's a very long time. And I think Enver's point in his earliest contribution was much more about the fact that if you allow a bill to pass into law which treats children as if they were just cut down adults and applies adult strictures in a child-specific setting, what you are not doing is guaranteeing their rights. You're not creating a system that is child-appropriate or child-specific. And one of the things, this is a very complex piece of legislation, obviously, because it layers legal aid and sentencing and young people and children and adults all into one big piece of legislation, and it will be difficult in its implementation if you're not very clear about what you mean by a child. So, for instance, under paragraph 109, there is under 18 and under 17. There are elements of the bill that say a child is under 18, but the caution is for those under 17. I really do think you have an opportunity to create a piece of legislation that is very clear what you mean by different age groups and how they should experience the system, and how they experience the system when they're children may well stop them being adult offenders if we can get it right. This bill has been trailed as a very big opportunity to change things very much for the better.
Kate Green.
So to follow a point made by Enver Solomon in relation to treating children like adults, and that's around curfew, where I think you expressed concerns that the curfew provision was being read across to children with the potential that they could receive curfews of up to 16 hours. What specifically are your concerns about the impact and risks to children and young people of that provision in the bill?
I think there's a number of issues here. Children who are subject to a curfew and children who get caught up in the youth justice system are often children from particularly vulnerable backgrounds where there might be family conflict, particularly domestic violence, abuse or neglect. We know the overlap between children in the youth justice system and those that are on that have experienced abuse and neglect is very clear. A curfew of that length could potentially trap them in a home where they are already experiencing abuse and neglect and the consequences of domestic violence. In addition, their opportunity to participate in education and other positive rehabilitative activities would be severely limited by such lengthy curfews, and they are likely also potentially to exacerbate any mental health problems or any communication difficulties that they might be experiencing, and limit their capacity to get support around special education needs and so forth. There's also a further risk of ratcheting up with this provision. It's the escalator effect that was referred to earlier, that sentences might fail to use it to divert children from custodial sentences, so it might not be used as an alternative, but instead will apply longer curfews to children who might otherwise be receiving shorter ones. So you get a net widening effect rather than it being used as an alternative disposal. So there's a number of concerns that I've outlined there that I think need to be taken into account, in particular in relation to this provision.
What solutions would you like to see in the bill?
Well, I think we need proportionate curfews and curfews that need to be combined with support packages. You know, anyone that works in a youth offending team will tell you it's no good just slapping a curfew on a young person if you're not going to give them a package of support to address their needs holistically. If you just give them a curfew and hope that somehow then that will address the reasons behind their behaviour, well then that's an unrealistic approach. Of course there needs to be proportionality, but we need to recognise that we can't just apply curfews to children and expect them to change their behaviour. We need to apply some packages of support as well.
Can I ask, maybe particularly Councillor Simmons, but others may want to answer. The bill gives more responsibility to local authorities in relation to children remanded. Now that may be welcome to some parts of the criminal justice system. Is it welcome to local authorities? And assuming it is in principle, from a practical point of view, is there a resource implications here? And how are both the courts and the local authorities going to respond to that?
I think the question you've asked is in two parts there. The principle is broadly welcomed by local government. We already do and manage quite a large proportion of this work anyway, and I think it will make the whole position much clearer for all concerned for that to be in one place. I think when it comes to the specifics, as always, the devil is in the detail of this. In the case of my own authority, 64% of young people who are remanded or in secure accommodation are aged 17. So that is groups of young people who are classified not as juveniles by the court, in which case there would be another disposal, but are young people who are legally adults but are treated in a slightly hybrid way under the current system. And I think there is a question over whether it is appropriate for the full local authority care system to be applied to all young people who find themselves remanded. And I can think of my own experience of being in a situation with a young person in the court where the issue was that they'd committed a violent crime which had resulted in them being estranged from the family. The key issue was that person going to be able to go home to their family? The answer was yes, but that was discovered after the court had taken the decision that they had to be remanded because there was nowhere else for them to go. Now, is it in that situation appropriate to say that that young woman in this case would be subject to the whole position of care? Now, at the moment, the Children and Young People Now organisation estimate that would be an additional 3,000 children coming into the care system in the UK across all the different age groups. Clearly, that is quite a costly prospect, so there is the usual concern that we would have about ensuring that the funding was adequate. And I think when it comes to the technical operation of secure accommodation, in particular the prison service, we would need to ensure that prison service secure accommodation was sufficiently flexible to take account of needs. So at the moment, the nearest secure accommodation to my authority, which is in West London, that provides secure accommodation in the prison service is in Bristol. And that means that any social worker carrying out their duties under the various care provisions has to go to Bristol, that in planning for that young person's return to their family, to their local area, to education, which may be within the space of a few days in some cases, they need to plan that from Bristol. And if the prison service, for technical or practical reasons, decides that they need to move them to HMP Dearbolt in County Durham, then our social workers will have to go to County Durham to carry out that work. So I think there is an issue about ensuring that the practical side of the system is geared up to deal with it if those young people are going to be the subject of the normal care services that are provided by council.
Maggie Atkinson.
Chair, I think there's a broad welcome from across the sector really to the notion of moving towards a far more care-based system, because you'll know that something like 45 to 50% of those who are remanded currently into youth offending institutes and other settings are actually on remand. and many of them are never found guilty. They are released, but they're locked up on remand anyway. So moving to a more care-based system, we welcome. As has just been pointed out in some detail, the devil will be in the detail of the implementation. At what point do the provisions of this bill trump the 1989 Children Act, which has got detailed and already legally binding strictures on local authorities as to what is a child in need, what is a child in care proceedings, what does a care order look like? If you mean Section 20 of the 1989 Act, you need to say it on the face of the bill. If you don't, you need to say it. Do you know, otherwise what you'll get is local authorities thinking, have we got the right accommodation? Do we have secure beds? Have we got the right trained staff? If he committed the offence over there, is he still ours or is he theirs? And so the devil is going to be really in the detail. So it's welcome the principle tremendously, but be careful what you wish for if you don't get the detail right.
Enda Solomon.
Yeah, we fully endorse the principle here and fully endorse that children remanded into custody should be given care status. My understanding from officials is that they will have Section 20 care status. I agree with Dr. Atkinson's point that it's important to make that clear perhaps on the face of the bill, but I think there's an important principle here in what this legislation is trying to do with the use of remand. The Standing Committee has a reputation for always being overtly critical about government in what it's trying to do with the use of custody. Here we want to wholeheartedly support what this bill is trying to do in relation to the use of remand for under 18-year-olds. The number of children remanded to custody is almost double the number of adults remanded to custody. There is an overuse of remand for children, an inappropriate use of remand for children. Half of children who are remanded into custody are either acquitted or given a non-custodial sentence. We have been wasting vast amounts of taxpayers' money on needlessly locking up very vulnerable children for short periods on remand. This legislation introduces a very clear barrier to the use of youth detention and a very clear incentive to use local authority accommodation, and as I understand it will incentivise local authorities to use resources to respond to children who come to court facing remand decisions where a decision has not been given to grant bail, will incentivise local authorities to support those children where appropriate in the community while setting down very clear barriers for what need to be met in terms of the use of secure custodial remand. So we do not believe that it would result in any young person who is a threat to the community or has committed a very severe violent offence. That child would still be remanded into custody, but we welcome the measures which we believe will dramatically, hopefully, reduce the needless use of custodial remand for many children.
If Helen Goodman has recovered, I invite her to ask the last question.
Thank you very much. I just want to ask, is there anything which is not in the bill which you would like to see in the bill?
Dr. Atkinson.
You'd expect me to say this. I would dearly love to greet the first piece of legislation that overtly and explicitly quotes the articles of the United Nations Convention on the Rights of the Child.
David Simmons.
I would tend to agree with that proposal from Dr. Atkinson. I think there are two things that would be helpful. If Section 20 of the Children's Act 1989 is to apply, and the Leaving Care Act, which amends some of it, and that is a case that will apply to all young people who are going to remand, then the cost of providing that care will increase exponentially. So I think there will need to be due consideration given of what the full implications, the full cost implications of that are, and whether that is what the government and Parliament specifically intends. And I think I would very much welcome some clarity about precisely who is responsible in law. So in a situation, as was quoted by Solihull Council, family relocated after some real issues that they had in Brixton to Solihull. Within a month of arriving, two young men in the family, both under 18, had committed a murder. Who is responsible? Is it the court in Birmingham, and therefore Birmingham local authority where the case was heard? Is it Solihull, where they briefly resided and where the offence was committed? Is it Brixton, the London Borough of Lambeth, where they'd originated? And I'd say from experience as a magistrate in Brent, we have cases from all over London that are heard, Is it the local authority where the person lives? The one
Order.
where the
Order.
authority is?
Apologise for interrupting Councillor Simmons, but we do have to stop at 4:45. I'd like to thank all 4 witnesses for giving up their time and giving evidence to us today. Thank you very much indeed.